Okay, the case before the Supreme Court, Hobby Lobby versus Sebelius, Secretary of Health and Human Services. It's a challenge to Obamacare, the Affordable Care Act. And it has to do with what's called the contraception mandate. And it's the idea that contraception is a part of preventive care in the Affordable Care Act, and the relevant regulations to make that real in insurance plans contains 20 different possible contraceptives that can be covered. So the main concern of the Green family, the evangelical Christian family that is controlling interest in Hobby Lobby company, is that they are concerned that 4 of the contraceptions that are covered under the Affordable Care Act are abortifacients. And even though the American Medical Association and other medical groups don't consider the IUDs and the morning after pills to be abortifacients, Hobby Lobby owners do. And they consider, therefore, the Affordable Care Act and the relevant regulations to be a violation of their corporate religious freedom. Now, this is a first in the history of American jurisprudence, because the corporations never claimed to have any religious freedom before. It was a secular for-profit business, a chain of craft stores. And but the case has somehow made it all the way to the Supreme Court. And the significance of that, there are a couple of them. And one is that you have the ownership group saying that the corporation has religious freedom, which basically means that any private citizen can claim that they have the right to violate federal laws and regulations because they have a religious objection to it via their corporation. This is an extraordinary thing because it means that whoever has a faith claim can trump science and medicine and even law, even to the point of violating the religious freedom and conscience of their own employees. There are lots of people who are employees of Hobby Lobby who probably use IUDs and would love to have them covered. But that wouldn't be allowed because some members of the Green family happen to think, against all reason in science, that these are abortifacients. And that's an extraordinary thing. If Hobby Lobby prevails in the Supreme Court case, that will open the door to many other kinds of medical claims. Scientology, for example, objects to psychiatry. And Scientology has many, many businesses. Jehovah's Witnesses object to the use of whole blood products, so perhaps surgeries wouldn't be covered if faith objections to medicine and science and insurance coverage can prevail here. And that's just the medical side of it. We're not talking about religious agencies here. There are plenty of businesses that are, say, owned by the Catholic Church. We're not necessarily talking about things like that. We're talking about secular for-profit businesses that happen to be owned by religious people. And whatever their idiosyncratic religious notions may be, they would prevail. And of course, there is one eccentric curiosity even to that, is that people change their mind about matters of religion, including even matters of abortion. Pro-choice people become pro-life people become pro-choice, and they still are people of faith. If entire classes of people can be given or denied medical coverage because of the ever-evolving faith views of a few owners of corporations, that throws everybody's life into a tizzy, and in a very arbitrary way. Now, one of the interesting things is that if Hobby Lobby prevails, it's not going to affect a very large number of people necessarily. It may affect them very, very negatively, and other corporations may end up doing this too. But the real significance of the case in a larger legal sense is that this is the first time that a corporation has been allowed to have a religious viewpoint. And religious viewpoints needn't be restricted to matters of medicine and insurance. They can get into issues of civil rights and employment. And, for example, if a company is owned by Southern Baptists, does that mean that it could be a male-dominated environment in which the denomination's views of the role of women, for example, comes into play? Should women get equal pay for equal work? Should they be in the workplace at all? They only be in subservient positions. We begin to look at exemptions in that sense from federal civil rights laws and labor laws. It's a crack to become a massive fissure in terms of the relationship between employers and employees if arbitrary notions of faith can be applied to areas of federal law and regulation. Historically, religious freedom, religious liberty, the right of individual conscience has been about individuals. It's not primarily an institutional matter. Even churches in the colonial era, part of the purposes of the Constitution was to disestablish the state churches, so that the right to conscience was endowed in individuals, and not in an all-powerful state or a powerful religious institution with close ties to the state. If you wanted to believe in Anglicanism or Congregationalism or atheism, you could. And you could change your mind as often as you wanted to without interference from these powerful entities. Now, institutions that are religious agencies obviously have a unique and sometimes gray area relationship to these areas of the law, and there are no neat answers to any of these things. But what's completely different in this case is a secular corporation claiming to have the religious freedom that's the equivalent of an individual. And that's just unprecedented in American jurisprudence. And I think that the framers of the Constitution would be very shocked to see something like that. Well, I think that the main value for Hobby Lobby and other kinds of cases of this nature is it gives them an exemption from the law. It sets precedent that if you have a religious objection to federal laws and regulations, that you can say, well, you know, I have a conscientious objection to that, and therefore you get a pass. And the more precedents that you have in areas of getting exemptions, the more exemptions you can seek. And you can widen the exemptions for future litigation, and it opens up a whole era of test cases. If we get an exemption in one area, we're going to see a lot of them. And that's just going to be the way it is for the foreseeable future. Another area of religious exemption coming from a little different angle is legislation in the states. As marriage equality is advanced, the Christian rights have to figure out what then to do. And in sympathetic state legislatures, they have, with the help of Focus on the Family and their state level affiliates, pushed, and the Alliance Defending Freedom for that matter, pushed for legislation that would grant businesses exemptions from recognizing gay couples and gay marriages. If their conscience tells them that's okay. It's a religious freedom exemption for service. That's often been compared to the refusal of service of African Americans in the pre-civil rights era at lunch counters. It's probably the most overtly discriminatory legislation we've seen in recent American history. It affects Christian Americans and non-Christian Americans alike. If people walk into a store or a bar or a lunch counter and say they're perceived to be gay, they may be refused service. It's about perceptions and about the sacralization of bigotry. And if people don't like your looks, then you can just get the hell out of here. Well, we kind of have to wait and see until the Hobby Lobby decision comes down. It could go their way. It could go against them, or some compromise ground could be found as well. You just never know how it's going to be with the Supreme Court. But one thing I think that people can begin to do is to really think through what religious liberty means to them, and from their own religious and non-religious perspectives, because religious liberty belongs to everybody, and there's no one religious or political faction that owns it. And if the Christian right is allowed to define it, they're going to advance it in their way. And to become knowledgeable and articulate about these things, and not simply to say, well, there's freedom of religion, but what about freedom from religion? That's clever, but it's not enough. And because freedom of religion is freedom from religion. That's the very context in which it means. Your religion is your own religion, and not somebody else's. nobody has the right to impose another religious point of view on you. And to own that, even if you're non-religious, religion may not be a comfortable word, but it's the word that has defined all of our legal history. So we're kind of stuck with it, whether we like it or not. But that's the reality. Religious freedom, religious liberty, more or less synonymous, is going to be one of the defining issues of our time in terms of what individual and collective rights are going to mean in law and in culture for probably the lifetime of everyone looking at this.